Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. Jurisprudence class. Friends, since the past 2 days we have been discussing different case laws on the reasonableness, test of reasonability. So we have discussed so many important cases like lastly we discussed this Kishan Chand Arora, then State of Madras versus Vijay Rao, Dwarka Prasad Lakshmi Narayan versus State of UP and two others. Kishan Chand Arora, we already know this case. Then Haradhar, actually it notes I have witness Hardhan, it's not correct. Haradhar Saha versus State of West Bengal. This case is on preventive detention. Now, we are going to discuss another case law. These are all the case laws relating to the test of reasonability by officers. Like the Commissioner of Police, Calcutta, by the State of Madras, like that. What about the reasonability clause, whether it applied to the governor or not? Yes, test of reasonability. The Supreme Court will decide with the power of the judicial review. Of course, you will be knowing that the power of the governor about his satisfaction regarding the existence of the circumstances to promulgate the ordinance cannot be questioned as per law. This is given in AIR 2005, Rajasthan, page number 144. Why I am discussing this? Because you can read the case as D C Wadhwa, DC WADHW, Wadhwa and others versus State of Bihar 1986. The judgment came in 1987. So 1986 case. So in this case, the powers of the governor under Article 213 of the Constitution India have been questioned. Yes, according to order Article 213, its heading itself says, power of the governor to promulgate ordinances during recess of the legislature. That means when the legislature is not in session and if there is any emergency, he can pass the act in the shape of ordinance. Of course, once the legislature reassembles or within 6 months, it has to be placed before the legislature and get approved, otherwise it becomes null and void. But what happened in the state of Bihar? It is shocking to note that, already we discussed the case, shocking to note that 256 ordinances were served by the governor. They were issued by the governor of Bihar. So, D C Wadhwa, who was a professor of economics in Gokhale Institute of Politics and Economics, Pune, right? He questioned the rationality or reasonableness regarding the 256 ordinance issued by the governor. So actually 256 ordinances were issued. They were alive for 1 to 14 years and of course by repromulgation from time to time. Why? Because the bill will be introduced at particular time. Within 6 months, the legislature will not, once again they will assemble on sessions. At that time, the bill will not be passed. It will be lapsed. So once again, they will take in the shape of ordinance. Like that, it has been renewed from time to time. Actually, I am presuming, I am not sure, when the governor was asked about the number of ordinances, even the government does not remember how many ordinances were issued. Now they have been figuring as 256. And 19, I think out of 256, 69 were repromulgated several times. Of course, with the permission of the President of India. So, please remember, these ordinances, they relate to Bihar Intermediate Education Council, this one. Second is Bihar Forest Produce Ordinance. And third one is Bihar, bricks supply control order. So likewise, so many acts are there. So regarding this, they have issued so many ordinances. So here, the main point here is can the governor go on issuing ordinances under 213 of the Constitution like this? So normally it can be done when the house is not in motion or when the house is not in sessions. But giving ordinance in a massive scale is not correct. So the matter has come to the Honorable Supreme Court of India. So even though the governor has got the so-called colorable legislation, doctrine of colorable promulgation, so it is unconstitutional because it is nothing but fraud on the Constitution. No doubt, maybe a governor, maybe I told in the beginning that Rajasthan case that the satisfaction of the governor cannot be questioned, but the way in which he has given the orders, they have been questioned. So the court is of the view that the executive authority, that means the governor, took over the role of the legislature. Actually, he is the boss of the legislature, but the executive authority, they cannot take the role of the legislature in making the law. So it is clearly contrary to the legislative scheme, contrary to the constitutional spirit. So please remember, such practice shall not be continued in future. Of course, particularly the Intermediate Education Council that has been immediately waived off by the Supreme Court, and some other acts were there in force. They have kept them in force because the ordinance was still having in power. So ultimately, they have awarded rupees 10,000 to D C Wadhwa because he has researched the entire issue, took out the GVOs, so many GVOs. Even the government doesn't know the existence of so many GVOs. Even the governor himself doesn't know that he has promulgated or re-promulgated so many ordinances. So this case is a fine example of how the ordinance power can be circumvented. That is nothing but abuse of the ordinance power, ordinance making power by the governor or whoever authority may be. So very classic case of test of reasonability. ఇది బీహార్లో జరిగింది. మీరు గూగుల్లో చూసినా వస్తుంది గ్యారంటీ, దీంట్లో అనుమానం అక్కర్లా. సో గవర్నర్ గారి పేరు ఒక పర్టికులర్, ఎందుకంటే పెద్దోళ్ళు గారు మనం చెప్పకూడదు. ఆ టైంలో కంటిన్యూస్గా ఈ యొక్క ఆర్డినెన్స్ ఇస్తూనే ఉన్నారు, ఎందుకంటే వాళ్ళ మనుషులు లేరు. లెజిస్లేచర్లు పెడితే గ్యారంటీగా వీగిపోతుంది. అందుకని లెజిస్లేచర్ టైంలో ఉండగా పెట్టకుండా లెజిస్లేచర్ అయిపోతూనే వెంటనే ఆర్డినెన్స్ వస్తుంది. మళ్ళా లెజిస్లేచర్ మళ్ళీ అసెంబ్లీ అయ్యేటప్పటికే ఆర్డినెన్స్ వీగిపోద్ది, మళ్ళీ నెక్స్ట్ ఇంకోసారి వస్తుంది. అట్లా 14 సంవత్సరాల ప్రకారం ఉన్నాయి. కాబట్టి దిస్ ఈస్ నాట్ రీజనబుల్. వెరీ క్లియర్ కేస్ ఆఫ్ unreasonableness, not fair. So that's why please remember, let him be governor, but the unbridled or unfettered powers, definitely they give the abuse to the ordinance making power. Therefore everybody should be careful. Andukane Supreme Court, that's why Supreme Court is the guardian of the Constitution. Otherwise ila ordinances istune untaru. So very classic example, a negative example for the test of reasonability. Please read the case law and enrich your legal knowledge. With this I am concluding. Thank you very much.